the majority side and the minority side. On my left are the whips, and on my right is the minority leader. This is also a presentation that had been endorsed before by the Senate, and it captures the issues that are not only related to the Senate alone, but also to devolution itself as a whole. As you know, Mr. Chair, it's now 10 years since we promulgated our Constitution, and August this year will be celebrating 10 years. The presentation we are making is informed by the experience, the actual experience we've had in the Senate. Slightly more than a quarter of the senators who are here, including yourself and the member of the steering committee, Senator Amos Wako, have had almost now 7 years experience within the Senate. This presentation is informed by that experience. Mr. Chair, it's our submission that there has been a clamor, even if you look at the report, because this is a validation process. If you look at your report, the people of Kenya want dispersal of power to various institutions and to various offices, to the extent that they will feel that there is ultimate representation in different places of governance in our country. It is a submission of our committee that by strengthening the Senate, we will answer to that call, that the people of Kenya will have a proper representation in various institutions, including the Senate itself. Our argument is that if you weaken the Senate, because, as I said, this is based on our experience in terms of passing of bills, in terms of debating bills in the Senate, it's our submission that if you weaken the Senate, you undermine leadership and you undermine institutions, then you deny the people of Kenya the opportunity to utilize the people they elected to a house that has a representation on matters of devolution. Mr. Chair, our presentation, and let me just emphasize there, if you look at Senate all over the world, including, let me give the example of the United States, many people who may have desired to run for presidency and provide leadership nationally, when they are unable to serve at the position of the president, they always find the Senate as the right institution where they can be and provide leadership. It's not by accident that you see, even at the moment, the leading Democrats, Democratic Party candidates are both senators, or previous candidates are now sitting in the Senate as senators. And you know, 16 presidents of the United States have come from the Senate. So Senate, if we really want, and it is our submission also that we need to remove from our heads the discussion of the institution of the Senate from the people who are sitting there at the moment, including ourselves, so that then objectively, because in the past when we have had disagreements with National Assembly, county assemblies, governors and so forth, those disagreements have clouded the minds of many people to think that it's just about today. But that's an institution that, if you look at the American Senate, when people have served in the states as governors, now they come and serve in the Senate if they can't be presidents of the country. We must make Senate that way, so that then we reduce this clamor and fight for wanting to be the president. There is also wisdom in the idea that in many Senates, politicians who've served more than 30 years, 40 years or so are serving in the Senate. There's a reason to that, because that is the place they find they can continue making their contributions. And I think that is something we should keep in mind. That's why we come before you, having the responsibility as the current senators to make a case that the Senate as a house must be made what it ought to be. We have avoided, Mr. Chair, to use statements like upper house and the like. I know many citizens would like to use of the word upper house versus lower house. Ours is more of functions, looking at the functions and the responsibilities they are going to contribute. This presentation, therefore, is divided into about 11 parts. The first part is the role of Parliament itself. We have submitted that in Article 94 of the Constitution, it provides the shared roles of the National Assembly and the Senate, and Article 95 and 96 of the Constitution sets out the specific roles of respective House of Parliament. In the case of National Assembly, the special role extends to, among others, representing the people of the constituencies and special interests in National Assembly. For the Senate, the special role is, among others, representing the counties, serving to protect the interests of the counties and their governments, and exercise oversight over national revenue allocated to county governments. The roles of the National Assembly and the Senate are set out in these articles, has often led to multiple and differing interpretation of the roles of the two houses of Parliament, particularly with regard to oversight of the legislative role of the Senate. The Senate has therefore observed that there is need to provide clarity on the shared role of both houses of Parliament and on the special and specific roles of each House of Parliament. To this end, the Senate recommends that Article 94, 95, and 96 be reviewed so as to clearly set out the shared roles of both Houses of Parliament, namely legislation, oversight, and representation, and also provide for the special roles to be assigned to each respective House of Parliament. In this case, National Assembly, the special role to extend to representing the people of constituencies. For the Senate, the special role is that representing the counties, serving to protect the interests of the counties and their governments, and exercise oversight over revenue allocation to raise by or otherwise received by the county governments and the expenditure of the revenue. Emphasis there is that oversight should not just be confined to revenue raised nationally as it is at the moment. It must include also revenue raised by the counties. You look at counties like Nairobi, Nakuru, Mombasa, Kisumu, the revenue they raise can also surpass the ones allocated from the national level. Number two is to look at the legislative mandate. At the moment, the legislative mandate is provided for in Article 109 of the Constitution and provides the legislative mandate of both houses. But Article 110 defines, constricts first of all, 109 constricts the functions of the Senate to only bills concerning counties. And the bills concerning counties have been defined in Article 110. The Senate has observed that as presently rendered in the Constitution, the provisions on the legislative mandate have led to the different interpretation as to legislative mandate of the Senate, particularly in the context of definition of bills concerning county government under Article 110A of the Constitution. Owing to the different interpretations of the Article 110 by both the speakers of National Assembly and the courts, legislation that concerns county government have often been considered and concluded by the National Assembly without reference to the Senate. As a result, the Senate roles of representing counties and protecting the interests of counties and their governments has been undermined. The question of what constitutes a bill concerning county governments was one of the questions before the Supreme Court in advisory opinion, reference number 2 of the 2013. The Supreme Court settled this question. And I don't want to save time, I don't want to quote. You will find the quote in our paragraph 17 of our submission on what the courts consider to be a definition of a matter concerning county. But suffice to note that the Supreme Court gave purposive interpretation of that section that covers almost everything, and in fact concluded by saying, with a good speaker, the Senate should be able to find something that affects the functions of counties in almost every legislation or every bill that comes to Parliament, making it a bill that must be considered and passed by both houses. They even went ahead to give examples of how security and policing, although national government function, affects the delivery of functions in the counties. Despite the advisory opinion, the question of whether a bill concerns or does not concern county government continues to arise and often impedes the smooth processing of legislative business in Parliament. It is in this regard that the Senate was compelled to file a petition number 284 of 2019, again after the 2013 petition in the High Court, after the 2013 advisory opinion. Then we filed a petition in the High Court, Constitutional and Human Rights Division, seeking further directions from the court on the application of Article 110(3) of the Constitution, and seeking declaration that 28 acts passed by the National Assembly are unconstitutional, null and void for non-compliance with legislative process set out in the Constitution. Mr. Chair, you can imagine the consequences, the dire consequences of such a declaration, which would have saved a lot of costs if the bills were passing through both houses as expected by the Constitution and left to interpretation of the speakers. In order to address the challenges noted and taking into account the legislative process of comparative jurisdictions, the Senate proposes to amend the Constitution to confer full legislative mandate on both National Assembly and the Senate. In this regard, clauses 8 to 15 of the Senate Draft Constitution of Kenya Amendment Bill 2020 provides for a legislative process that takes into account and provides clarity on the role of both houses of parliament in the processing and passing of legislation. What we've done, Chair, is to make sure that in our presentation we've attached an annex of a draft bill. Makes it easy for your committee to look at what is our thinking behind how bills shall be processed, among others. And therefore, even when your experts and secretariat is considering, there is already a draft that is attached to this presentation. The third issue is the approval of nominees for appointment to state office. The Constitution requires the approval of National Assembly prior to appointment of persons nominated for appointment to the following offices, which is the Clerk of the National Assembly, High Commissioners, Ambassadors, Diplomatic and Consular Reps, and other state or public officers, Cabinet Secretaries, Secretary to the Cabinet, Principal Secretaries, Attorney General, Director of Public Prosecution, Chief Justice, one woman and one man representing the public in the JSC, Chairperson of Commission Revenue Allocation, Controller of Budget, Auditor General, Chairperson, Vice Chairperson, 7 other members of the Public Service Commission, and members of commissions under Article 250. The Senate is required to approve the appointment of the Clerk of the Senate, and in the case of appointment of Inspector General, the Constitution requires the approval of both houses, which includes the Senate. The Senate observes that in most comparative jurisdictions, in order to ensure equity in the appointment of persons nominated to serve in the office, the second chamber of such jurisdiction had a critical role to play in the approval of officers nominated to state offices. Mr. Chair, in our submission, you see the Senate plays a role of equity, and so approvals of state office holders is very necessary for equitable distribution of positions across the country. The Senate recommends as follows, that all approvals of nominees for appointment to state offices relating to the formation of government or which have direct bearing on the performance of government of the day be approved by the National Assembly, and that approvals of all nominees for appointments to state offices not directly related to the formation of government and which enjoy security of tenure be approved by the Senate. The Senate therefore proposes that the approvals of nominees to state offices be undertaken as follows. The National Assembly to approve the Cabinet Secretaries, the Attorney General, Secretaries to the Cabinet, Principal Secretaries, High Commissioners, Ambassadors, and Diplomatic and Consular Representatives. And the Senate, Mr. Chair, to approve the Director of Public Prosecutions, Chair and members of Constitutional Commissions, Chief Justice, Deputy Chief Justice, Auditor General, Inspector General of National Police Service, and Control of Budget. The Senate noted that the building bridges to a United Kenya Taskforce report at page 11 made proposals regarding to appointment of cabinet to the effect that, and I quote, the cabinet shall be drawn from both parliamentarians and technocrats, with the latter being made ex officio member of parliament upon successful parliamentary approval, and further that to ensure more effective political directions and parliamentary accountability, there shall be a position of Minister of State that will be appointed by members of National Assembly and taking direction in their ministerial duties from the cabinet ministers. The Senate observed that if cabinet ministers, and this is important, Chair, because it's the emphasis on, it will depend on your recommendation now. We are giving alternatives based on if there will be a recommendation to that effect, which is that if cabinet ministers and ministers of state are to be drawn fully, either fully or partially, from within members of National Assembly as proposed by the task force, it would be inappropriate for the National Assembly to approve nominees for these positions. That is, the other ones who will be drawn from outside. Consequently, the approval process required under the Constitution would shift in entirety to the Senate for purpose of providing checks and balances. Similarly, the removal process of such state officers would also be undertaken by the Senate. Further, with regard to the composition of cabinet, the Senate observes that in comparative bicameral parliaments, such as United Kingdom, Australia, India, cabinet ministers and ministers of state may be drawn from either houses. However, in Germany, members of cabinet are only drawn from the lower house, the Bundestag. It's also noteworthy that in our independent constitution, ministers would be appointed from membership of the two houses of the National Assembly. The Senate observes that whichever model is selected for the constitution of cabinet, it would have a bearing on the approval and removal process of various state officers. If the membership of cabinet is drawn from both houses of the parliament, then you revert to the previous composition that then approvals are divided between the Senate and National Assembly, between state officers and the appointments that are dependent on the government of the day. The Senate recommends that the House of Parliament plays a role in approval process in a manner outlined earlier above. In ensuring the allocation of adequate financing to support the system of devolved government, the Senate just goes straight to the fact that we support the argument that we need to increase allocation to counties, and observes that in order to ensure the success of system of devolved governance, it was necessary to ensure that adequate funds were allocated to the county governments, and therefore recommends the amendment of Article 203(2) of the Constitution to provide for the enhancement of the equitable share of revenue raised nationally, that is to be allocated to county governments, from minimum of 15% to a minimum of 40%. The State Senate further recommends the amendment of Article 203(3) of the Constitution so as to provide that the amount equitable share of revenue raised nationally that is to be allocated to county governments be calculated on the basis of the most recent audited accounts of revenue received. These amendments are to be found at clause 33 of the Senate draft constitutional bill. The fifth issue is the role of the Senate in budget making process. Mr. Chair, the budget making process provided in Part 5 of the Chapter 12 of the Constitution, and on the whole, in our current constitution framework, budget making is the responsibility of the National Assembly. The Senate has a minimum role in the budget making process, yet the Senate, as mandated under Article 96 of the Constitution, is required to represent the counties and protect the interests of their governments. This is a responsibility that extends to the manner in which the resources of national level are allocated and utilized, and whether such allocation and utilization accords with the national values and principles of governance, which among other things include sharing and devolution of power, inclusive equity and discrimination, protection of marginalization and sustainable development. The Senate notes that in comparative bicameral legislature, the budget is presented by the executive to both houses of parliament for consideration by the House. This is the case in the US, Germany, Philippines, and Nigeria. The budget is passed only after it's approved by both houses. In the United States and in Germany, if the two houses do not agree on the budget, the matter is referred to the equivalent of our mediation committee for development of a consensus. The Senate recommends that for the Senate to effectively discharge its mandate under the Constitution, particularly the role of representing the counties and serving the interests of the counties and their governments, it is imperative that the Senate be involved in the budget-making process. The Senate therefore recommends Chapter 12 of the Constitution be amended so as to entrench the role of the Senate in budget-making process, including in the consideration and approval of budget estimates. The proposed amendments are to be found in clauses 37 to 44 of the Senate Draft Constitution Amendment Bill. In these proposed amendments, the National Assembly will retain a veto power on any amendments proposed by the Senate to the estimates. In all comparative jurisdictions, National Assembly, an equivalent of National Assembly or lower house in other places, retains the power to veto provisions that come from the Senate in relation to budget by two-thirds of the members. Mr. Chair, the sixth issue is entrenching the provision removal from office of county governor in the Constitution. Article 181 of the Constitution provides for removal office of a governor. In a nutshell, I don't want to go further than that, is that the Senate proposes that the provisions relating to removal of governor be lifted away from the County Government Act and moved to the Constitution itself, and also should provide directly that you will require a two-thirds of the Senate, just like you require two-thirds of the Senate to remove the Deputy President, and the President should also require two-thirds of the Senate to remove a governor, and that recommendation is provided for in Clause 29 of the Senate Draft Bill. On the Parliamentary Service Commission, this is a very key issue for us, also based on our experience, both for the 7 years, but also in researching on comparative jurisdiction. Actually, the vice chair of the committee, then Senator Mtula Kilonzo, visited Australia, and one of the very important commissions when it comes to this issue. We are proposing that Article 127 of the Constitution be amended to provide for Parliamentary Service Commission. Sorry, let me just read 41, yeah? Yeah. The Parliamentary Service Commission provides services to both the National Assembly and the Senate. The Senate observes that in most bicameral jurisdictions, each house was responsible for its own administration, including provision of services and facilitation to its members and staff. In such jurisdictions, only a few of the functions were jointly managed, for instance, library services, security, and common premises. The Senate recommends that the provisions relating to Parliamentary Service Commission be reviewed so as to provide for National Assembly Service Commission and Senate Service Commission, responsible for provision of services and facilities to membership and staff of the respective houses. The proposed amendments set out in Class 17, 18, and 18 of the State Draft Constitutional Bill. And Chair, let me just emphasize, the institutional checks and balance between the Senate National Assembly ends up to the staff and provisions of services to both houses. And there comes a lot of unnecessary fights between the two houses, but particularly between staff of both houses, competing as to who should do this, who should clerk which committee, who should provide which services. And it is very unhealthy. If you live within Parliament, you will see the struggles that members of staff are put into because of other constitutional checks and balances that are affecting between both houses. To avoid such situation, we should borrow from comparative jurisdictions and separate the service commissions of both houses, and then the both houses by legislation can form joint committees to manage what is called joint services, which is the library services, the buildings, and all the others. That is provided for here, and I wanted just to make sure that I emphasize that fact. And on the publication of county bills, we are proposing that on the question of Kenya Gazette, again, you will see there are court cases that deal with the struggle where when counties want to publish anything in the Kenya Gazette, because Kenya Gazette is wholly controlled by the national government. And in the County Government Act, it was envisaged that there will be County Gazette, and many legislation provided for County Gazette. In fact, many decisions of counties were annulled by the courts for failing to have been published in County Gazette, but there are no County Gazettes. So the best way to go about it, so that we have one Gazette that can come to when dealing with matters of this state, nation, the Senate observes that there is need to provide clarity on publication of county legislation, and in particular of such legislation was to take effect when published in the Kenya Gazette or in the respective County Gazette. In order to ensure clarity, efficiency, and coordination in publication of both national and county legislation, the Senate recommends that the office of the government printer be established as an independent office available to both national and county governments for publication of legislation and other legal documents on both levels of the government. And then to guarantee, I'm almost coming to the end, Chair, to guarantee independence of the county assemblies, again, county assemblies play a critical role in the county, providing checks and balance, but at the moment they are being stifled by the control the executive has in the allocation of their resources. The Senate and the National Assembly were freed from that by virtue of constitutional provisions. And in the same manner, we are recommending that the Senate further observes that it is necessary so as to ensure effective oversight of the county executive by the county assemblies, that the Senate recommends that county assembly service boards and the county public service boards be entrenched in the Constitution, and that provisions be made to provide for the financial independence and autonomy of the county assembly. We have proposed the same in clause 32 of our draft bill. The role of the Senate in international treaties. The Senate observes that there exists a host of treaties and conventions that impact on directly and directly affect the county governments. Yet such treaties and conventions continue to be ratified without reference to the Senate. The Senate further observes that, and Mr. Chair, this would be involve health, planning, education at the pre-primary level. It will involve agriculture, like Maputo Protocol, among others. So the Senate further observes that it is necessary for the Senate, in the discharge of the mandate relating to the county governments, to scrutinize all treaties and conventions before they form part of the laws of Kenya. The Senate recommends that Article 2.6 of the Constitution be amended to require the approval of both National Assembly and the Senate before any treaty or convention ratified by Kenya forms part of the law of Kenya. The proposed amendment is set out in Clause 2 of the Senate Draft Constitution Amendment Bill. And finally, Chair, state of the emergency and deployment of defense in Kenya. Article 58 of the Constitution provides for declaration of state of emergency and requires that it shall be effective for no longer than 14 days from the date of which the declaration, unless the National Assembly resolves to extend the declaration. Further, relating to deployment of defense forces within Kenya, Article 241(3)(c) of the Constitution provides that the defense forces may be deployed to restore the peace in any part of Kenya affected by unrest or instability with the approval of the National Assembly. The Senate observes that both these matters of security concern and affect the counties and the county governments, and that it is necessary that the Senate participates in the consideration of these matters. The Senate therefore recommends that both houses of Parliament be involved in process of extension of declaration of state of emergency under Article 58 of the Constitution, and also in the approval of the deployment of defense forces within Kenya under Article 241 of the Constitution. The proposed amendment is set out at Clause 3 and 51 of the Senate Draft Constitution Amendment Bill. The Senate therefore recommends to the Steering Committee that the committee adopts the submissions of the Senate to Steering Committee on the implementation of building bridges to a United Kenya Task Force. It is now our pleasant duty and privilege on behalf of the Senate to present the submission of the Senate to the Steering Committee of implementation of the building bridges to a United Kenya Task Force, signed by Senator Murkomen, Kipchumba, Senate Majority Leader, and Senator James Orengo, Senate Minority Leader, on behalf of the senators. The Chair, I don't know if we should present formally now to you.
After.
Or after? Okay, after the question. So, Mr. Chair, now I open the floor to Senator Mtula to add or subtract what I have